ahead and get started here. I know some more people are still coming in the back. If you can filter into the chairs. Ready? Okay. All right, good evening. Welcome to our Community Development Public Hearing. It's May 9th, 2024. The time is 6:02 p.m. I'm calling this meeting to order. In attendance are Commissioners Matari and Duncan. Commissioner Brooks is excused. However, if he is able to watch the recording, then he would be able to deliberate with us at a future time. Chairman's remarks. A lot of you have already heard this a few times, but maybe some of you haven't. Code of conduct for tonight. All public comment and testimony will be civil and respectful. Address the Board of County Commissioners and not the audience. Address issues and not persons. Refrain from applause as it interferes with due process, but do raise your hands if you're in agreement with the speaker. When asked by a county commissioner to stop, please do so promptly or face being asked to leave the meeting. If repeated requests by a commissioner are disregarded, the meeting will be recessed or adjourned depending on the issue at hand. On our first item, family division of land, if you already spoke to us at a previous hearing and you filled one of these out, please let us know that you've already spoken to us. I'm asking that we hear the people that we've not heard from yet, because we do have the cell tower issue, which will take the majority of tonight, and we have a 7 a.m. meeting tomorrow morning. So me, more than him, needs beauty sleep, and so I'm just asking to be respectful of that. So thank you. All right, changes to the agenda. We are dispensing with item 2. Our CIP impact fees has been canceled. And conflicts of interest?
None.
None here either. Item 1, ORA 23-0002, exempt family division of land. And this is a continuation from our April 11th public hearing. And I would ask that we, there's some staff considerations that brought up that I think the board needs to take into consideration. So I would ask that we put off the deliberation tonight for the family division until June 27th or July 25th. So Mr. Wickman, do you have a preference on those dates?
Yes, we would prefer June 27th. The earlier the better.
Okay.
I'll be around. So.
Okay, June 27th then is when we will take up the family division for deliberations. All right, we can go ahead and get started. And like I said, this is a continuation, so I am not sure that we need to hear from the applicant again, unless staff thinks that we should hear from them.
I don't believe there's anything new. Yeah.
Commissioners, there's not anything new that we know of from the applicant, but you received an email from us, the staff, outlining some thoughts that we have come up with that we just wanted to actually make sure we're in the record. So
Okay.
At this time, even though it's not, since it's a legislative matter, it's not required, I'd still like to have this introduced into the record so that anyone can find it online in IMS.
And commissioners, given that the staff is going to do that, I would highly recommend that the applicant be allowed to speak after that.
Okay, so as in rebuttal after everybody has had a chance to speak, or right now?
Even right, it could even be right after staff's presentation. I think I'd probably give them their choice,
Okay,
whether they want to speak right after staff or if they want to just wait until the end and give rebuttal.
okay. All right, so are you going to read this then, Ben?
If you'd like me to.
Well,
How about if we hit the high point?
yes, yeah, just
Sure.
go ahead.
Okay.
It's not that long.
So yes, staff did have an opportunity again to put some thoughts together on the matter, and to highlight some of those, we do have some concerns with highway districts' involvement at this point. We have not had the chance to hear back from the highway districts, whether or not there is going to be improvements required or fee in lieu of improvements required, because they do view this as a subdivision or a division of land, and that is typically how they've seen these things. Again, haven't been able to actually hear that from them, although I think we may be meeting with them soon. There is shared infrastructure improvements, including new and existing common driveways and private roads. So, of course, the family division exemption would not promote the infrastructure as currently required by the subdivision process, which is inconsistent with some of the goals and policies within the comp plan. The proposal does not require, again, similarly as the subdivision process does, to demonstrate availability of groundwater, knowing that groundwater is a concern for many people of the county, which is also, again, something that would be consistent or supported by the comp plan. There is some challenges that staff has with the administration of the proposal, should it go through, with regards to transfer of ownership before the 5-year period expires, and how we would process or administer building permits that are currently underway. Does that hold them up? Do they continue through? That's just, again, administrative question. This is just, again, a concern. House is built and CO is issued and property sold before the end of the 5-year. Possibly might be a way to get around some of those requirements. Confirmation of familial relationship may be challenging for staff. How do we determine who is a grandparent, who is a relative, as suggested in the proposal? There is the potential, again, that this could cause some proliferation of family divisions and large lot divisions. So again, a greater intensity on existing private roads. Does it comply with International Fire Code? I mean, what kind of challenges does the fire district face with this proposal? And since there is no fire district required approval in this application, that would be of concern. A demonstration of legal access, should that be part of the application process? Are there limitations on boundary line adjustments upon, are there limitations on boundary line adjustments that below 5 acres, for zones that support a smaller minimum lot size, such as the ag subzone, which allows for 2 acre, or restricted residential zone, which allows 1/5 of an acre, roughly. There's the potential, again, based on what we've heard, is that Spokane County, which part of this is modeled after, they usually experience, or somewhere in the ballpark of 200 exempt divisions per year. And if that were to be the case, if we experience something of similar nature, then that's largely the same what we experienced through the minor subdivision process as far as total number of lots go. And so there is the potential that this could really essentially replace the minor subdivision process. Let's see. We've got one of the points that the Planning Commission brought up in their analysis was that they felt like this may unfairly financially benefit property owners that have families as opposed to property owners that do not have families. And then lastly, allowing proliferation of family divisions within the agricultural zone is contrary to the intent of the comp plan with regards to the agricultural use. And then lastly, again, family division exemption allowed in the tribe reservation is in conflict with their position on intensifying development. So that's, again, a brief synopsis of that, and happy to answer any questions if you have any.
Okay. As far as Spokane goes, don't they have triple our population? So,
I honestly don't know, but I can say coincidentally, let me just admit these people that want to be online. All of the county directors, my cohorts throughout the state, just had an email this week about this very issue. And interestingly, Bonner County's director opined that this has been a difficult thing for their staff, and it takes up a lot of staff.
okay. Is that something that you could forward to us so we
Sure.
could be privy to that information?
Sure.
Okay. All right, at this point, would the applicant like to take time to rebut staff's concerns?
Thank you, Commissioners. Rand Wickman for the record, 2992 Gotham Bay Road, Harrison, Idaho. I'm happy to be here representing Vince Hughes, the applicant, tonight. I obviously don't have prepared remarks to address these items, but I'll wing it here a little bit. Some of these things I am prepared to address in my rebuttal, and I will defer those to that point. The first is the Highway District. They can view this however they want, but they do not have any history of viewing exempt divisions as subdivisions. And so I think that will be a challenge for them to somehow construe this as an exempt division as a subdivision. But we will deal with that when the time comes with the Highway District. Again, they do not consider 20-acre lots as exempt or as a subdivision. They don't make you go through any special process. You go and you get an approach permit for those. The same thing with testamentary provisions. I'll just kind of touch on a few of these. The resale of newly created parcels within a 5-year period, that is something that the staff will have to figure out how they want to handle that. You could make building permits non-transferable, for example, if you've got somebody who got one issued and it is transferred during the period that building is being constructed. You could make them get a new building permit as a new owner. And if the parcel hasn't gone through the 5-year waiting period, they have to wait. Again, they're gonna have notice of that in their title, and they will know what these restrictions are. And so, again, that's an issue that is not difficult to resolve. The staff would come up with a policy for it. It really is it's the same thing with item 5 there, the house is built and CO issued, property sold before the 5-year period. Yes, it is possible that could happen. And, we've made, we recognize that. It's not something a developer is going to do more than once because they are limited in how many properties they can do family divisions on. They can't go and do a family division on this property and then go to the next one and do another family division. You get one. You get one per kid, and you get one property as as the grantor. Again, we're kind of making up. We know staff's been opposed to this since the beginning, and so I understand they're trying to come up with lots of reasons why this is not a good thing. Obviously, you've got a lot of testimony in support of it that contradicts that. Again, we could talk about the exacerbation of inadequate infrastructure. Your real problem, and I will address this again in my other rebuttal, is your 20-acre free split, free for all. You have hundreds of parcels created under that exemption every year. You do not review for adequate or inadequate infrastructure regarding existing private roads or anything like that. This would be a small fraction of that. And so again, I encourage you to, consider the magnitude here. Spokane County does experience that. That's the same, that's consistent with our research in Spokane County. They do a couple hundred parcels a year. And they do not have anywhere near the limitations on their requirements that we have proposed here. I, as a developer, if I were one, I can go a parcel, give parcels to my kids. I don't have any. If I did, and then I do that, and then I can go to the next parcel and do the same thing over and over again in Spokane County. They seem to be okay with that, or at least the commissioners are, from what one of the planners over there told us. And so, of course, you're going to get much more activity. They are also approximately 3 times the size of Kootenai County with regard to property, or with regard to population. This idea of unfairly financially benefiting individuals with family, the world's not fair, but give me a break. We are doing this to help families, stay families, and, everybody does have a family. You came from parents, even if you don't have any brothers, sisters, or kids, you didn't come from nowhere. And, some people don't have a family anymore, and that's too bad. But, I mean, those kinds of things are just silly, and I'll just leave it at that. I'll have additional comments to address in my rebuttal, and thank you for the opportunity.
All right, yes.
The internet tells me the population of Spokane, according to the census in 2020, is 522,798.
Okay, thank you. All right, any other applicant or applicant representative? I think we have Rob Stanton and Vince Hughes. Save that for rebuttal. You want?
I spoke at the last meeting.
Okay. Well, do you want to save it for rebuttal, or do you want, being the applicant, you have a little bit more leeway, and especially if you're gonna, okay.
Some of them were mentioning to turn up the volume somehow. Is there something that I can do?
Can we turn up the volume in the back of the room? Sorry, and I'll put my microphone closer too.
Vince Hughes, 11791 West Prairie Avenue, Post Falls. Thank you for the opportunity to address the commissioners. One of the things that we do know is that there's a need for family divisions in Kootenai County. Okay, last meeting, and I think later tonight we'll hear from families who are directly affected by this and who would benefit greatly from this. Okay, we also know that other jurisdictions have these type of family divisions. The Bonner County, Spokane County, the state of Montana has a provision in its land code. We know that there's some need because the draft that Rand Wickman started with came from county staff. So there's obviously a need. I think that the hang up are the what ifs. How do we implement this? I think most of us agree that this would be a big benefit for families. And then we get into the details of how could this go awry. And I think that all of us, whether as individuals, parents, business owners, elected officials, you have to do risk-reward analysis. You have to ask questions about what ifs. But then I think that we weigh the risks and the rewards. Should I let my child go downhill skiing? Okay. Kids get hurt downhill skiing. What can I do to mitigate that risk? Make sure they're wearing the proper equipment, helmets, etc. Give them a ski lesson. Give them some supervision. All of us, or most of us tonight, made a decision. Should I get in my car and take the risk of driving to this meeting or not? It's a risk that all of us take. But based on our experiences, historical analysis, you figure out what the risk is of you dying or being hurt in this car accident on the way here. What are the road conditions like? So I think that when we get to this particular proposal, we have to do some analysis and see what unintended consequences could be. I think one of the things that we do is we look at other jurisdictions. What happens in Spokane County, which Mr. Wickman just talked about? What happens in Bonner County? What happens in the state of Montana? And there's countless other jurisdictions across the U.S. that have family divisions. And what are the provisions to discourage abuse? I think that we have many in here. Individual only, okay? It can't be an LLC or some corporation that gets involved in these family exemptions. It has to be individuals, a husband and wife or an individual. There's a waiting period from the time that you buy the land before it becomes even eligible. There's a limit on the number of parcels a person can grant to a relative, and there's a limit on the number that they can receive. The historical perspective, can give us thoughts on what will happen, okay? And there was a situation that was brought up at the end of the last meeting, at the very end, where somebody takes this 80 acres and makes 16 parcels through this combination, okay? Could that happen? Is it a what if? It could, okay? Historical perspective tells us it's not going to, okay? In the late 90s, the subdivision ordinance in Kootenai County was fast, it was affordable. You can make 4 parcels in 2 or 3 months, cost you less than $5,000. Did anybody create 16 parcels for their family members during that time? No. The testamentary provision allows people to do the same thing. Are people in their testamentary using that exemption to create 16 parcels? No. Could it happen? In theory, yes, but in practice, it won't happen. This division will be used to benefit families, some of whom you'll hear from tonight. The last thing I'd like to bring up is let's compare and contrast the 20-acre exemption and the family division that's proposed. 20 acres, no waiting period. Buy a large parcel, start creating 20-acre parcels immediately, apply for building permits immediately. No limit on the number of parcels which can be created by an individual or a corporation. Developers can take this 20-acre exemption, they can use it time and time and time again as a repeated business model. Family division, there's a waiting period before you can even apply, okay? The created parcels must go to a family member. The created parcel has time limits before it can be sold for building permits. There's a lifetime limit on the number of parcels an individual can give away, and there's a limit on the number that you can receive. So if you're a profit seeker in Kootenai County, which one of these exemptions are you going to use? I think it's pretty clear to us. Where do we go from here? I believe the families of Kootenai County need and deserve the passage of this family division amendment. And thank you for your time.
All right, Mr. Sawyer, Dennis Sawyer, do you want to speak? Okay. All right, Alan White, have you spoken before?
No, that was my wife.
Okay,
She's much more eloquent.
all right. In favor, wishes to speak.
Alan White, 14816 North St. Teresa's Way in Rathdrum. I'm in favor of passing this because I've got children. I've got a nice parcel. I'd like to leave them without taking $40,000 out of my pocket and having to do a major subdivision. I think Rand addressed it pretty well, a lot more eloquently than I could, and so did Vince. But I just wanted to lend my support and let you know that a lot of the objections that we hear, I think, as Vince so eloquently said, are small by comparison. We're not talking about putting dozens of homes on a 40-acre parcel. We're talking about dividing it up between myself and my 3 children. And the safeguards that were mentioned in place, I think, are a great idea. I just would like to know when we might be able to make a decision, because this has been kicked down the road for almost a year, better than a year, a year, April. So if somebody can make a decision, or if somebody can hear back from the highway district, because it's been a month since our last meeting, and I'm surprised that nobody's been able to hear back in a month. So that's what I'd like to say. Thank you for taking the time.
Thank you. And just to remind everybody, we'll be deliberating on June 27th. So, all right. Gail Allen, in favor, wishes to speak?
I'm Gail Allen. We live at 3998 East Custer in Athol. We have a little over 10 acres, 10.05, I think it is. And we're getting older, and we're wanting to split the property with our son, Chris, and his wife. And they want to be able to help take care of us, and we're going to help take care of their children. That's all we're looking to do. The house prices are so high, you can't even get a starter home at $350,000 hardly. And have parking, have a place for your children to play. It's just not available. And unless they leave the area. And they've moved here because they want to be here. So, and they want to be around us. And that's how we feel. We have looked into this division, and we're already being told that it's going to be $30,000 to $50,000. Well, we're retired. We don't have $30,000 to $50,000. But we do really need the help. And I just want to say that we are definitely for this, and thank you for your time.
Thank you. Nick Corwin, in favor, may wish to speak? Okay, thank you. All right, Beth Corwin, in favor, may wish to speak?
Hello, I'm at 14011 North Reflection Road in Rathdrum, and my husband spoke last time. But all I wanted to say is that we've already put a lot into it because we've been doing it as a minor subdivision. And it has been 3 years, and we all are living in one small house on top of each other during this process. We've looked at the other options, right? We've looked at additional dwelling units, and it's just not feasible even for that. For one thing, my parents are here, and it was their land, and originally for the last, since 79 or 78, they've been paying taxes on 15.12 acres. When we just had our survey, it came out to 14.8 something. So now we can't do 3, right? Because if you have the 5 acre minimum, we're zoned for 2 acre parcels. But again, that makes it so we can only do a 2 under this. So I would like to say having it based off of the zoning would definitely help us out as a family, because me and my brother are getting the land from my parents are staying. So if we were wanting to do it as a 3 divisions, so that, 3 parcels, so that my parents could stay, and then my brother and I could each have our own parcel, and we wouldn't have to do an additional dwelling unit based off the original house. It's cost us a lot of money, and as far as setting up the infrastructure, I know Bruce mentioned that last time that you'd have to do it anyway, right? But it's about having the money up front. We don't have the money up front to set up the infrastructure for the minor subdivision requirements. If we had the division, we could get the loan against the land or one of the existing, my parents or whatever, to do the infrastructure. And is there a way to tie the infrastructure, right, to the building permits? like, you have to have access to the parcel, right, to do a building. So could that be a way to kind of ensure that part? Anyway, that's what I have to say. Thank you.
Thank you. Are you doing timer? Okay. Oh, okay. All right, Lee Chase, in favor, may wish to speak?
I spoke at last meeting, but I'd like to speak again.
We don't have time tonight. So if you spoke at the last meeting, then we're not going to have time tonight because of the second hearing that we have. But you can submit an email to us if you like. So,
That's garbage. Okay.
well, if we've got time at the end, I can see, but at this point, we're pretty packed tonight. Gregory Allen, in favor, may wish to speak?
Yeah, I'm Gregory Allen, live in Athol on Custer Street. My wife just spoke a few minutes ago. So we were blessed a few years back to pick up a 10-acre parcel. It was a fixer, and we're not wealthy folks, but had no intention of doing any subdivision, selling off half of it or anything else. But my son and his wife looking for a home, can't really afford it. And we'd love to gift it, a half of it to them. But the subdivision complications are just overwhelming. And I'd just like to encourage you guys to vote this thing in. Thank you very much.
Okay, Roger, is it Busey? Bussey. All right, may wish to speak, or? Oh, I'm sorry about that, in favor, okay. And Gerardo Fuentes Lopez, in favor, does not wish to speak. Sandy Perkins, in favor, does not wish to speak. Dale Perkins, in favor, does not wish to speak. And if you change your mind, folks, please let me know. Rodney Dickinson, in favor, and it does not say wishes, does not wish. So, I'm sorry, Rodney, you want to speak? No, okay. And Chanel Dickinson, in favor, does not wish to speak? I'll speak. Okay.
I'm Chanel Dickinson. I live on 21st Street in Post Falls, Idaho. I was born and raised here, so is my husband. Family's been here for generations. I work in healthcare. My husband works for a nonprofit. We do fine, but we could never afford to purchase a large piece of property on our own and just develop it. My in-laws, fortunately, as part of their retirement, decided that that's something they wanted to do, and they want us to live close to them and be with them as they get older. And so this would make it doable for both of our families so that they can be close to us, we can be close to them. Then in the future, the plan would be as our kids get older, then they would have the opportunity as well. Because in 10 years, even if my kids were doctors, it would be difficult for them to buy property around here.
Okay, thank you.
Thanks.
Chris Allen, in favor? Okay.
Yeah, I'm Chris Allen. You've heard from my other family members, I think my folks. We've been in the area for a while. We really like it here. We do want to do this minor subdivision, and we can appreciate that it's a lot of extra work for the county staff. Without it, it's a lot of extra work and cost and time for us, and it's almost punishing, but really a shot in the arm for the families, and I don't think I'm alone here, is, aren't families the the foundational building blocks of communities. The shot in the arm for the families, I think it will give, this community, I think would be huge, and I really appreciate your consideration. Thank you.
Thank you. Okay. Neil Hanch, in favor? Does not wish to speak. Okay. Is it Kenna Allen, in favor? Does not wish to speak. Teresa, oh boy, is it Chenault? Okay, in favor, does not wish to speak. And we are here back to the rebuttals and the applicant. So what I would say is, yes, sir, did you?
Excuse me, I didn't have an opportunity to fill out one of those papers.
Okay, come to the front. Yep.
I appreciate that, thank you. My address is 11401 East Kempton Road, Coeur d'Alene, Idaho.
Your name?
My name is Michael Burns.
Okay.
And I'm 31, I have 3 children, and I have a really great neighbor who sold me a piece of land. Owner financed it, great terms, not an outrageous interest rate. I'm able to live with my family in Kootenai County, that's great. My next brother, he's 27, he's a registered nurse. He's married and has his first child on the way. He, as we speak, lives in an apartment in Post Falls, and he just recently bought a mobile home in Rosalia, Washington. So he and his wife and child are leaving the county. Next sibling of mine, she is 8 years younger than I am. She's married and has 3 children, and she and her husband live in Shoshone County with his parents, so they can't afford a piece of property in this county. The next sibling, he's 10 years younger than I am. He's engaged and he's moving to Canada with his Canadian fiancée because they can't afford in this county. So that's just a real testimony of a family in Kootenai County. So just letting you know that there could be a need for this.
Thank you.
Thank you.
So how many people spoke at the last hearing besides Mr. Chase and would like to speak again on the family? Nobody else? Okay, Mr. Chase, come on up.
Well, thank you, and I owe you an apology. Last meeting, I didn't realize we were moving on to another subject. I apologize for that. But due to a death in the family, my son can't be here. But to stress the importance of this, the death in the family, they found the man 10 days after he died because he lived alone. And the folks here that introduced new information to this, it's new information, and they're nitpicking on the highway district, the fire district, those rules are already in place. We don't have to change them. It's the fast track to get the people that need the help. I'm a veteran. I'm a disabled factory worker, maintenance worker. And with just a stroke of the pen, you put it off for another month. Planning and zoning is giving us a hard time because I have my son living on my property. We're doing everything in our power to be within all the specification and rules. But you're making criminal out of good, hard-working people. So I just don't understand how come it did take so long for people to understand that. I thank you kindly for your time.
Thank you. Okay, last call. Oh, we have Zoom now. Okay, go ahead.
Commissioners, you have 2 people on Zoom. I don't know if they want to speak to this
Okay.
issue, but I thought now would be a good time to open it up.
Sure.
If you're on Zoom and you want to speak to this issue, please unmute yourself and go right ahead. Why not?
Okay, then just one last time for the audience. Anyone else to speak for or against the family splits? Okay, then I will call on the applicant representative for rebuttal.
Thank you, Chairman Duncan. Again, Rand Wickman for the record, and I too would apologize to the commissioners. Clearly, I'm a little frustrated that, we've been in this process for 13 months now, and we get what I expect at the last meeting. We get a list of some new concerns and issues from staff. Again, we've been at this for 13 months. It would seem to me we have, addressed all of the other concerns we could think of as staff came up with them through the process, and now we're getting 2 pages of them tonight, and so again, I apologize for my frustration, but it feels a little bit like a game of whack-a-mole here. And so let me go back through some of the previous concerns that have been raised and address those, and I think I'm through this in about 10 minutes, so I'll go through as quickly as possible. Issues that have been raised, the first was the cost savings issue and whether there's really a cost savings here over the minor subdivision process. Well, I did an evaluation of the various expenses associated with a minor subdivision compared to what we expect with a family division process. The difference for a 2-lot minor subdivision versus creating an additional lot by family division is about $30,000 for an average minor subdivision. Now, I can provide a more detailed breakdown if you want, but those savings come from the difference between a plat and a record of survey. There's a surprising amount of difference there. The difference in application fees for the county and other agencies. The fact that you don't have groundwater reports, conceptual engineering, and other issues to address. The total savings is going to vary based on the specifics of any given project, but the savings are real and on the magnitude of tens of thousands of dollars. And again, if you want specific numbers, I can give those to you. If you have questions about that, I'll get through this and we can go through them if you want. Another concern was this issue of water problems for other property owners because a groundwater quantity engineering report is not required. The engineering reports required by the county for subdivisions do not meaningfully prevent water quality problems for other property owners. In cases where low flow wells are likely, the groundwater report typically proposes water storage as the solution. Water problems can occur in much of Kootenai County, whether your lot was created with an engineering report or not. And that is why we have water rights and extensive case law to provide relief and address issues when they occur. Another concern was the impact on reservation and land in the agricultural zone. I think on balance, the family division is likely to do more to keep true farmland intact because without it, the owner is faced with dividing off 20 acres at a time instead of just 5. How many families will take advantage of all 4 of the exempt divisions, thereby separating 20 acres off of the family farm? Probably not too many. The number of families that need just 1 additional parcel is probably the most common scenario for using the family division, and that would only pull a 5-acre parcel out of the family farm. In that more likely scenario, the family division option just saved 15 acres of the farm. Also, none of the other subdivision ordinance exemptions are tied to specific zoning, none of them. Why should families living in the ag zone or on their reservation be given fewer rights than other residents of Kootenai County? Staff time is another issue. Staff time to process the family division exemptions has been raised. I believe this amendment should be promoted as a move toward efficiency in the department. Most of the family divisions will likely be in situations where they save a family from going through the minor subdivision process. That saves the staff from processing another minor subdivision. And minor subdivisions are going to be far more time-consuming than family divisions will be. Staff also gave you an example of a situation where they divided up 80 acres by first using the large lot exemption for 20-acre parcels, and then another round of splits by family divisions by 3 or 4 subsequent owners that are related. And I think that's another highly unlikely scenario. But let's unpack that a bit. So if I had 80 acres and 16 kids and or grandkids, and wanted each of them to have a 5-acre parcel, the more straightforward approach, the more straightforward way to get there is with a carefully crafted will. I will die soon enough and will then have complied with the testamentary provisions of the code. The county will have 15 more parcels than we started with, and each of those grandkids will remember me a little more fondly than probably otherwise would have. But there are no restrictions, no additional waiting periods to keep track of, no application to the county. Pretty simple. As a single individual, I really can't get to 15 or 16 parcels, 15 additional parcels, through the family division because I'm limited to 4 in my lifetime. To get to 16, I have to collude with some family members by first giving them the 20s. Then they have to wait 3 years. Remember, we got a waiting period there. And then as the owners of the land, those, let's say they're my kids, they can do a family division to what would be my grandkids after 3 years. I will bet that that middle generation, my kids, that own the 20s, only does a family division if it's really beneficial to their family. And think back to all the reasons that we proposed this in the first place. The likelihood of each of the recipients of the 20s having similar plans for the property, the patience to wait out the waiting period, and a sufficient number of kids to grant the property to also seems to share the odds with getting struck by lightning. Not impossible, but not likely to be a pattern of behavior that your staff is going to see regularly repeated. And to back up this scenario a bit, I would argue that the problem isn't with the carefully constructed provisions of the family division. Rather, the problem is the free-for-all that is the 20-acre large lot division. It is those exempt 20-acre divisions that are used by the large landowners, the developers, the speculators, and they're used every day, and they're used to avoid the major subdivision process and significant infrastructure improvements like public roads and new public drinking water systems. And then rinse, wash, repeat. They move to the next property and do it again and again, as often as they can find suitable parcels to buy. No limits, no waiting periods. If the concern is preventing abuse of the system by developers and speculators, then you should fix the provision that enables that abuse, not penalize the families that are withholding a solution that is carefully crafted to discourage that very kind of behavior. And so in closing, I will state that there will probably always be bad actors that seek to test the limits of any set of rules that you'll come up with. In this case, we have built in as many safeguards as we could think of to prevent that. The benefits to Kootenai County families that are already here are many, and they're very meaningful. You've seen and heard the support that exists for this proposal. I again respectfully ask for your approval and appreciate this quality time that we get to spend together. Thank you.
Thank you. Any questions?
Actually, I do. I just would like to know if you have those notes that you could give to for the record, so we could include those.
Just send us an electronic copy.
Sure, I can, absolutely. Yep, I've got the numbers here. I could go through them quickly if you want, otherwise I can just send them to you.
If you could send them, that'd be fine. That'd be great.
Absolutely, be happy to do it. You'll have them in the morning.
Thank you.
Thank you.
All right, with that, I guess some of my questions would be for staff or legal. When do we know if it's a material change that's going to require another public hearing? And if so, can we just continue this public hearing if there's changes that rise to that level? Or do we just end public testimony tonight and enter into deliberations in June?
Well, if the recommendation of the planning commission was to deny the request, and so if the board is inclined to approve the request, I think we do have to have one more hearing, and I would ask that be expedited as much as possible. I think we can go ahead and continue that if it's tonight, if it's to a date certain. If it were to a date uncertain, we would have to renotice it.
Okay, so if we just say June 27th, we'll continue it then. So are we ending public comment or not if we have these material changes?
If you're gonna do that, then the motion would be to continue to June 27th to
Satisfy our second
take any
public
addition,
hearing.
yeah, exactly.
And then we could go into deliberations if we
Yes.
so chose.
Yes, you could.
At that point. And I think that's probably the better way to go, is to
Yep.
continue and then have the option to go right into deliberations on June 27th,
Yes,
it is.
yeah. So just a motion to continue then till June 27th?
I move that we continue the public hearing for the exempt family division of land continuation, which is ORA 23-0002.
Second.
Commissioner Matari?
Aye.
Chair Duncan?
Aye. All right. Now, you want a break or are you good?
Well, I'm good.
Okay.
Yeah, thank you.
All right, item 3 on our agenda is CUP 23-0003, and this is the reconsideration of the I-90 Wolf cell site. And we'll give folks just a minute to exit. Thank you. And again, I just want to remind folks, we want to try to get through as much, all the testimony tonight. And so just raising your hands when you agree with the speaker is very helpful. All right, who is going to start us off? Will Pat start us off? Give us a little information.
Yes, I can start off, given the nature of the hearing tonight. I'm Pat Braden, I'm Civil Deputy Prosecutor, for the record. This hearing is a request for reconsideration of the Board of County Commissioners' decision to deny the request to install a cell tower on property located within the rural zone alongside a 4th of July pass on interstate, or off of Interstate 90. That order was entered on February 13th, 2024. We did timely receive a request for reconsideration from the applicant. This hearing is being conducted pursuant to Section 67-6535 Idaho Code. Subsection 2A provides the legal standard for this hearing. It is failure to identify the nature of compliance or noncompliance with express approval standards, or failure to explain compliance or noncompliance with relevant decision criteria shall be grounds for invalidation of an approved permit or specific authorization or denial of same on appeal. This is also governed by Title 8, Chapter 8, or Article 8.5 of the Kootenai County Land Use and Development Code, which provides requirements for request for reconsideration, the actions the board can take on request for reconsideration. And it also provides a somewhat different order of testimony and submission of evidence than your typical public hearing on an application. The Section 88506C states that as a general rule, the following order of presentation should be observed. Introduction of appeal or request by staff, and I would admonish staff not to take a position at that time, just simply introduce the case. Then the appellant's case in chief, that would be the party requesting reconsideration. Then testimony and or evidence in support of the appellant. The county's case in chief, if any. Testimony and or evidence in support of the county's position or in opposition to the appellant. And then the appellant has the final say in rebuttal.
Okay. Is that it?
Yes,
Thank you.
that's it from me. I'm
Okay.
sure staff has other comments.
Yes. All right, so we will start with staff to introduce the appeal.
Good evening, Ben Tarbutton, Community Development for the record. As you know, Amy Hilland formerly was the planner on this case, but she has taken a position elsewhere. So as Pat Braden had mentioned, this is a request for reconsideration on CUP 230003, which is a wireless communication facility. This is an abbreviated presentation, so if you have additional questions, feel free to let me know. But the property, at the time that the original application was submitted, it was an 80-acre parcel. The property owner has since exercised large lot divisions and is now for 20-acre parcels. And I'll show you that map here in just a moment, but it is located near the Wolf Lodge area off of Alder Creek Road. Again, this is more of an overlay of that 80 acres originally and the location of the proposed cell site. On the left, you'll see the zoning map, and on the right, of course, the comprehensive plan map. You'll see the executed large lot divisions as they are currently configured, and then that lower parcel to the southeast is 20 acres, and that's still where the cell site would be located. Here is a site plan showing the access coming off of Alder Creek Road, which is a private, it's a public road, but the actual access itself would be a private road serving the proposed site. Here is kind of a zoomed in version of the leased area for that particular tower. It's a 100 by 100 leased area. An overview of the project is a 150-foot lattice tower and shelter. Again, as I mentioned, 100 by 100 fenced area. And the intent, of course, is to fill gap in communication along Interstate I-90. Just some history for you. Again, the application was determined to be complete and sufficient August 29th of 2023. First public hearing we had with the hearing examiner was on October 25th, 2023, in which they did approve the request, or recommended approval of the request. On February 13th, 2024, the Board of Commissioners denied the request. And then on February 26th of 2024, the department received a request for reconsideration. During the public comment period for this public hearing, we did receive 29 comments, one which was in support of the applicant or the appellant in this case. 27 were in opposition to the appellant or the applicant again, and one comment did not have any comment or designation as either support or opposed. The comments in opposition are similar to those received for the other public hearings in that there was concerns with aesthetics, increase in potential fire risk or danger, health concerns, additional cell coverage is unnecessary. I mean, they felt that there was adequate coverage, and potential decrease in property values. But that's it that staff has prepared at this moment.
Okay.
I did also want to enter into the record, the applicant has provided earlier this week a document from a gentleman, his name is Ryan Novak of Novak Insurance, addressing the potential increase in insurance costs based on alleged fire danger. So I'd like to enter that into the record now.
Read into the record is B 1001.
Actually, make that be 2001. We already have a B 1001.
This will be B 2001.
All right. Yep. Yes, please. Thank you. Okay. All right, now we will go to the appellant, and I assume the appellant's on Zoom.
That'd be Watanabe? Ms.
And-
Watanabe, if you'd like to unmute yourself and go ahead at this time, that would be helpful.
Yes, can you hear me?
Ms. Watanabe, if you'd like to unmute yourself and go ahead at this time, that would be helpful.
Can you hear me?
Yes, we can.
You'll have to mute YouTube, though, if that's on.
That's what-
Can you hear me?
Yes, we can hear you.
Can you hear me now?
Yes, we can hear you.
Yes, we can hear
Yes, can
you.
you hear me? Oh,
Unmute yourself and go ahead at this time. That's-
can you hear me? Yes,
You'll have to mute YouTube, though, if that's on.
Can you hear me?
Yes.
One moment. Don't. Can you hear me now?
Yes, we can hear you.
Yes, we can hear you.
Okay, I think I cleared up the YouTube problem. How's that?
Much better, thank you.
Can you folks hear me now?
Yes, please go ahead. Apparently, she might not be able to hear us.
Can you hear me now?
Yes, we can hear you. Can you
Hear
hear?
me now?
Can you hear us?
How come she's not on the screen?
Can you put
She doesn't have her, she doesn't have her.
picture up?
on.
Okay.
Can you hear me now?
Yes.
I'm going to have to.
Take a break? Yeah. Tell you what, folks, let's recess for 5 or 10 minutes as long as we can get this up and running. Thank you.
Okay, thank you. Good evening. I'm sorry there is a technical difficulty somewhere. For the record, Ann Watanabe, 109 South First Street, Rosslyn, Washington, 98941, counsel for the applicant, Rice Towers. I want to thank the staff for the introduction, and I also want to thank counsel there for the legal preambles, which are also reiterated and stated in the reconsideration document, so I'm not going to go over those now. And since this is a de novo reconsideration request, I'm going to focusing on additional information that is presented in the applicant's request for reconsideration. So to supplement the entire existing record, which the applicant believes that in its entirety establishes that the board's denial of the CUP was made in error. So I'm going to focus on those aspects. And so rather than repeat all the reasons that are stated in paragraph Roman numeral 1 through 20 in the reconsideration request, I'm going to just highlight the new information and clarifications of the evidence for the board's reconsideration, and then address why the evidence in the record does not support denial of the CUP, which effectively denies the applicant due process to a fair and new hearing based on the entire record. So I'm going to discuss the 4 points that the board raised and then tie them back to my Roman numeral references and reasons that are in the body of the reconsideration document, which I lift out not to be inclusive or exclusive, but to highlight them in relation to the evidence presented that I'm going to discuss. So the first action one that the commissioners suggested we could present to perhaps get approval would be to present sufficient evidence of a significant gap in coverage with real-time data. So I tell the board now that the applicant did submit this already into the record, and it doesn't appear to have been properly considered by the board. So the board's analysis in their decision document suggested that Verizon had provided some RF information and that Verizon did not provide proprietary data supporting the drive test, and that was not submitted in the record for them to consider. But however, Verizon did submit that information into the record, and it's presented in the hearings exam. Okay, thank you. Good evening. I'm sorry there is a technical difficulty somewhere. Can you hear me? For the record, Ann Watanabe, 109 South First Street, Ralston, Washington. Can you? Okay, I'm sorry. So Verizon did submit that information into the record, and that is presented as Hearings Examiner Exhibit 2002. And so that information did sufficiently evidence a significant gap in coverage with real-time data, and that is drive test data that's real-time, that's created by Verizon employees, and it's data that's generated to attempt to place calls on the commercial network using a handset and software that's available for customers. So these tests were available, they were presented by Verizon, and they should have been properly considered by the board. So I just want to make sure that you are aware that that information that was noted as proprietary on Verizon's RF study that was presented in the initial CUP application, that was subsequently presented by Mr. Paul Slotemaker, who is also on the line, but he may be having problems as well. So that information was there, so I would just ask you to reconsider that. And then in addition, the applicant also submitted RF coverage maps and crowdsourced data from the online data tool, which is called Cell Mapper, which also evidences a significant gap in coverage. So I also want to know, because I want to sort of contradict the evidence, which I believe the board relied on, and one of those is Exhibit B-1005, which was an exhibit to the board, and then also a hearings examiner exhibit HE2005. And that one was presented by Mr. Joseph Whipple, and he suggested that the case law suggests that significant gap in coverage does not include in-building and in-vehicle coverage. And I will suggest to you in my footnote 5 in the reconsideration document that is totally inaccurate, that case law that he cites, which is T-Mobile W Corp versus City of Huntington Beach, that clearly states that T-Mobile has a gap in building and vehicle coverage. So I just want to contradict that piece of evidence that was presented into the record. And so to tie that first request back to my reasons in the Roman numerals in the consideration document. Number 10, rule number 10, the board ignored substantial evidence in the record showing engineered RF maps, real-time drive test data, and crowdsourced data that depict a significant gap in coverage along I-90 with high traffic counts, and wrongly relied on unverified, untested, anecdotal statements by members of the public about their personal coverage experience, which does not equate to substantial evidence and cannot be a basis for denial of CUP application. And to that, I'm going to guide you to a footnote number 2 in the reconsideration document, which is the case Extenet Systems versus Village of Kings Point, which clearly states that that court was consenting with the current court that comments from residents that their service was inadequate do not constitute substantial evidence, and further holding that unverified, untested, unanecdotal statements by board members and residents about their personal coverage experience are not enough to call into question a carrier's otherwise undisputed objective evidence. So moving back to my reasons under your request for real-time data, Roman numeral 11, the board failed to explain how the applicant's RF maps and CellMap or crowdsourced data maps and Verizon's RF maps and the real-time drive test data are not complete and insufficient to establish a significant gap in service coverage. And then again, Roman numeral 14 reason, the board failed to show the existence of any available technologically feasible alternatives to remedy the significant gap in service coverage along I-90 as demonstrated by Inland and Verizon. And again, I will lead you to a footnote, a consideration document, which is T-Mobile versus City of Anacortes, footnote 4, which clearly says that when a locality rejects a prima facie showing of a significant gap in coverage, it must show that there are some potentially available and technologically feasible alternatives. And further continues that a speculative alternative is not a viable alternative. So the board in its order asked why the applicant did not consider U.S. Forest Service sites, and I tell you that they were considered, and they were presented in Verizon's RF study, included with the initial CUP application. So maybe that wasn't exactly clear, but that site was what is called the Killarney Mountain site, and that is a site owned by American Tower. And that site was deemed infeasible by Verizon in its RF study. So again, I'd like to bring that back to your reconsideration to let you know that that requirement was met and that evidence was put into the record. And then tying back to Roman numeral 15. The board ignored the applicant's alternative site analysis that rejected U.S. Forest Service sites for not being technologically feasible alternatives, and therefore ignored substantial evidence in the record to wrongly deny the CUP application. So again, that site was in Verizon study, so I encourage you to take a look at that and reconsider that. The board's action number 2 suggested to the applicant was to present sufficient evidence that there would not be an enhanced fire risk associated with the installation of the facility, or that such risk is adequately mitigated. So again, there is insufficient evidence in the record to demonstrate an enhanced fire risk associated with the proposed tower that the applicant is asked to mitigate beyond the conditions of approval. So as already indicated in the record, the Kootenai County Fire District did not indicate any concerns or fire risk and made no recommendation to mitigate. So you need to just make sure you're including the comments and recommendations from the experts. And for mitigation, to adequately mitigate risk, the tower is going to have a lightning grounding rod, and the area will be cleared of brush and underlying vegetation, of course, without violating condition of approval 8.13 that requires the applicant to preserve and maintain existing vegetation for proper screening of the site. So now I would like to talk about the evidence that was presented into the record by members of the public. There was information presented in Hearings Examiner Exhibit 2003. That was AGU Publications, Antenna Structures, and Cloud to Ground Lightning Location, 1995 to 2015. I am suggesting that that is not dispositive evidence that the proposed cell tower will create increased risk from lightning strikes. If you look at that study carefully, you will see on particular images in there, in particular on page 5204 of the publication, it shows that in Idaho, the cloud to ground occurrences are 0 to 5%. And that towers constructed prior to 1996 have higher lightning strike occurrences than modern towers. And then image C from that exhibit presented by the public, which is on page 5207, page 61 of the exhibit from the Higgs hearing examiner, shows that only one data point in Idaho State, which is nearly 500 miles from the proposed tower location. And now that tower location is not related to the CUP, and it's not that information in that evidence submitted into the record is not a concern in this application, because that report doesn't apply to what's going on in this particular area and cannot be a base, which is 500 more miles away. And again, 0 to 5% ground to cloud to ground strikes. That can't be a basis for denying the CUP. So again, mitigation, the proposed tower will be engineered and constructed to modern tower construction standards for fire and wind, and will have engineered electrical grounding equipment. Now, it's important to note that grounding equipment is not for, it's for lightning protection, not lightning prevention. So, in the unlikely event of a strike, the grounding equipment will intercept the lightning strike and disperse the electrical discharge safely into the ground. Well, so grounding equipment will mitigate for possible lightning strikes, and it actually makes the tower, if you will, a safer strike than a tree, an underground tree, which is more likely to ignite in fire and more likely than not if struck by lightning. And lightning, in fact, was the second leading cause of wildfires in Idaho in August of 2023. So looking at U.S. Forest Service lands creates more of a dense timbered type of environment for higher risk. And I'll just suggest some quick data here in Idaho. The Idaho Department of Lands in August 2023 documented 198 wildfires. 152 were caused by humans, the other 46 by lightning, none by cell towers. And I lead you to footnote 6 in the reconsideration document. So, and in terms of residential fires, the leading causes of residential fires are other things such as cooking and heating equipment, and this is information that is coming from State Farm, one of the leading insurance underwriters and providers in the nation. I lead you to footnote 7 in the reconsideration document. So again, to tie that back to my Roman numeral reasons, it's the reason number 9, again, not inclusive, but the board relied on public concerns and opinions about speculative fire and increased homeowner insurance premiums, neither of which are substantiated in the record and cannot be used as a reason to deny the CUP application. So I would just like to go back and mention what Ben mentioned, which is the insurance letter from Novak Insurance. Bit of background there. Novak Insurance is representing TowerCo. TowerCo is a national tower company, and so they can speak smartly and wisely about how tower sites are handled in the insurance underwriting world. And it is, as my reconsideration document speaks of, which is relating it back to the Insurance Services Office's fire rating, and I can speak to that more. But that letter affirms that and takes the speculation away out of people's concerns about having increased fire premiums. And I do want to say that later this evening, about 5:30, I did receive another similar letter from an insurance provider stating the exact same thing, and I would like to submit that in the record. I did send it to Ben by email, so I'm not sure if he could introduce that in the record now, or perhaps it's appropriate to leave the record open for that reason if nothing else comes up during this hearing. So I'd just like to make that request so that I could get that other insurance letter into the record, which came in later today. So going back to the Commissioner's Action 3 request to the applicant, the Commissioners suggested that we present sufficient evidence that there would not be an economic hardship to the surrounding homes associated with fire insurance, basically increase in annual premiums. Again, I back to those letters of people who are in the industry, not speculating, but are attesting to how insurance is handled with cell towers and in communities related to fire risk. And I won't go into the whole detail, but it is related to insurance service offices, and it's also related to the Kittitas County Fire and Rescue's public protection classification, which is based on a variety of fire suppression rating schedule criteria. And one of those I might mention has a 10% weight for emergency communication, which could not occur without having fixed mobile broadband services. So those are criteria that are pertinent across the U.S. So I do believe we have been able to provide additional information for the Commissioner's consideration regarding the concern about insurance premiums and property values in that regard. And I think it's also interesting to note that the Kittitas County Fire Rescue Department mentioned recently that their last 10-year review cycle was an improvement in our rating, and that was dependent on devotion to staff, as well as, I underline, the efficiency of the 911 dispatch system, which, again, wouldn't happen unless you had proper broadband and wireless and fixed and mobile services. So tying that action number 3 back to my Roman numerals, I'm going to suggest that the board relied on concern opinions about speculative fire and increased homeowners insurance premiums, neither of which are substantiated in the record and cannot be used as a reason to deny the CUP application. So again, I ask you to look at the insurance letter from Novak. And in addition, there was insurance information provided by Tilson, which was a Verizon representative, and they provided similar information about the ISO and fire ratings. And the fact that there were emails with Mr. Slotemaker's rep, our insurance contact premiums, and that the ISO rating is going to rule. Action 4 that the commissioners asked of the applicant was to present sufficient evidence that the proposal can adequately address site constraints and potential hazards and adequately mitigate any negative environmental, social, and economic impacts, like effect on property values, for example. So again, there is insufficient evidence in the record to demonstrate negative environmental, social, and economic impacts for which the applicant is asked to mitigate beyond what is in the conditions of approval. No social impacts were presented in the record. The applicant submitted a NEPA report into the record as Hearings Examiner Exhibit 2008, which indicates no environmental issues. So the evidence in the record is clearly not dispositive on the matter of property values to the 10, 12 people that received the notice being in proximity, the nearest of which is 770 feet away and separated by a road and timberlands. So again, going back and looking at the evidence that I presume the board relied on is faulty, I'm going to lead you to Hearings Examiner Exhibit 2000, HE 2006. That's a bit of an excerpted document. It can't be fully authenticated by me, but it does not have information for Idaho or the Pacific Northwest, but it looks at properties in Savannah, Georgia, and elsewhere. And that document is entitled Survey by the National Institute for Science, Law, and Public Policy Indicates Cell Towers and Antennas Negatively Impact Interest in Real Estate Properties. So that study is not dispositive, and I'm going to tell you why, and that is because that study, if you look at it closely, does not talk about properties that are zoned rural with a comprehensive plan designation of resource recreation. That study looks at residential neighborhoods and residences, quote unquote, within a few blocks of the tower. That is not representative of the surrounding properties adjacent or near the proposed tower site in the CUP application. The surrounding Kootenai County land use zoning of adjacent properties, the nearest being 770 feet away, are zoned rural, and they range between 7.5 acres to over 250 acres in size. So that's a far cry from looking at what might be suggested as neighborhood impacts. So the information, again, also presented in Hearings Examiner 2006, talked about, it was an excerpt from the HUD website, Housing Development website, and it suggests that cell towers are, quote unquote, a nuisance and a hazard. That study and those statements are irrelevant here because that information only pertains to improvements that are, if you read that evidence carefully, quote unquote, that are located within the easement, serving a high voltage transmission line radio TV transmission tower, cell phone tower, microwave relay dish or tower, or satellite dish, which is radio or TV cable, etc. And that, quote unquote, if the dwelling and the related property improvements are located outside the easement, the property is then considered eligible for HUD assistance and no further action is necessary, and therefore the location near the cell tower is not a hazard or a nuisance. So in this case, no adjacent or neighboring properties are within the proposed tower easement, making this information, or according to that evidence that was presented in Hearings Examiner 2006, absolutely irrelevant here and cannot be used as a basis to deny the CUP application. Now, further, again, what's in Hearings Examiner Exhibit 2006 is presented as a document entitled The Imperial Economic Letters, 2019-877. That is also not positive on the matter of property values and cell towers because it concludes, existing studies on the effect of a nearby cell tower on home sale prices have produced a wide range of inconsistent results. Some more find a large effect.
Hello, can you hear me? Ms. Montanabi, can you hear me?
Yes.
The time allotted has expired. You will get a chance for rebuttal at the end.
Okay, that's fine. I'm nearly done.
Okay. All right, we're gonna go ahead with folks in support of the, well, no, we're going in support of the reconsideration.
Yeah.
Yes.
That first and then.
Yep. Yeah, so we have Nathan Weiss.
And I don't know who's, or how to, necessarily how to fix it, but there was a lot of feedback when Ms. Watanabe was speaking, and I'm wondering if somebody's mic was on or something, that, or if there's any way we can.
I'll mute mine next time she speaks and see if that helps.
Okay.
Nathan Weiss, 601 R&R Heights, Ronald, Washington. I'm the president, CEO of Inland Cellular. We're licensed carrier here. We're the ones going on the tower. We've looked at the other tower that's on Forest Service property. It will not provide RF coverage in the area that we're looking to cover. We have ETC status in the state of Idaho, which is an elected telephone carrier since 2006. We also have FCC licenses in Kootenai County. We've been serving Idaho since 1989 with wireless service. We've been a telecom provider with landline services since 1967. I know there's no reasons to take in consideration RF emissions, but we could, since that was a concern, we could shoot and put our antennas so they're 45 degrees so we can cover the I-90 corridor and stop radiation from going to the north where the other residences are. So we can do narrow beam RF coverage so that the carriers have service there. You have Verizon's on the phone too, so they will be speaking on behalf of why they want this site. I drove, I'm as high as you get at the company. So I drove tests this 2 weeks ago with 3 phones, had people in the car, we did tests, and we dropped going through this corridor. I had all 3 carriers, different phones, testing the service. It does drop through this corridor. The thing about so there is a need, valid need. Us carriers do not put services where there's not a need and desire. Verizon has 1.4 million, AT&T has 100 million, T-Mobile has 119 million subscribers in the United States. So we've recognized there's a need, and T-Mobile's been looking at this location also. And stated I-90 Kootenai County, it serves Snoqualmie Pass. This is 4th of July Pass. So the emergency services that are needed, there's dead area there, so that's why we represent a lot about what's happening in Kootenai County and the I-90, because there is a need. And this is the only stretch of passes, if you want to class passes, from Montana to Seattle that has a dead zone. So we are all looking to fix that. The residence that's next door, that's 700 and some feet away, the tower site is 2,740 elevation. The house is 2,860, so 120 feet difference. The tower we're looking to build is 150 feet. And the reason is for additional carriers to go on there. Your code requires, it's not build and almost done. Code does not allow for just build it and they will come. We are building it because there's 2 carriers that want to go on this site, Inland Cellular and Verizon. Thank you. Any questions? I'm free.
Thank you. All right, we have Debbie Hanch in favor. Wishes to speak, does not wish to speak. Okay, and then I guess we have Verizon on the line as well, David, on Zoom.
Paul Slotemaker online. Paul, if you'd like to speak, please unmute yourself and go ahead.
Hello, this is Paul. If you can hear me, I cannot hear via Zoom, but I'll just say this is Paul with Tilson representing Verizon Wireless in the project. I don't have anything really more to add than what Ann has already entered into the record, so I think she did a fabulous job kind of addressing the items. Again, I can't hear, so I'm just going to leave it at that. Thank you.
Thank you, but you can't hear me, so I guess it's fine. All right. Anyone else that wants to speak in support? We have one neutral, may wish to speak. Do you want to? So Ron Hartman, neutral, may wish to speak.
Ron Hartman for the record. What I see missing in all of this, both sides, especially the Verizon people, is there's no business plan here. I don't understand the motive. Where's the profit? You haven't said what it is. You haven't said how many complaints you've had. I haven't heard one statistic on the number of complaints. Where I live, I got to drive down Kid Island Road. There's a known dead zone there. I know there's a dead zone. I've lost I don't know how many calls. A few minutes later, the call's back. I've got a real difficulty understanding the motive here. Normally, private enterprise with stockholders have to show a profit. Where is the profit in this project? I don't get it.
All right, thank you. So we are ready to go on to the county's case. So is that?
I think we can just move ahead to the people that are in support of the county's earlier decision and opposed to the reconsideration.
Okay. And we have Mark Mathis, and I'm going to go ahead and call out the names of the people who have given up their time for Mr. Mathis. And so if you just raise your hand, Bettina Whipple, okay, Carrie Mathis, and Sam Mathis, John and Julie Coleman, okay, Bob Bolich, okay, Michael Burns, okay, Cassandra Ryder, and Bill Brizzo, okay, and Lois Moore. All right, Mr. Mathis, please, you have 15 minutes.
Alrighty, do you have a clock or something I can look at? I would appreciate. Oh, 15 minutes? Okay, if you'll give me like a 5-minute warning, please.
Okay, and
All
Ms.
right.
Watanabe, let us know if you cannot hear.
Okay, I'm good, thank you.
Commissioners, I would say it's good to see you again, but be honest, I've been up here a lot lately, but thank you so much for taking the time to listen to the residents of Wolf Lodge. I also want to specifically thank, there's a lot of people in Wolf Lodge who donated their time. They're out here to support me being the closest neighbor, so that doesn't go unnoticed. I did notice in the applicant's rebuttal, they say one person, me, was the one concerned about property values. Please don't forget, 10 people have donated their time. They know what I'm talking about, and they're obviously willing to put their name on what I'm saying. So there's at least 10, not just one, that care about property values. I just left this up from the last time we were here just to remind you that you do have, per our code, that you can't approve a CUP unless it mitigates the three things in red. And obviously, I'm gonna primarily talk about the economic impacts. However, I did pull some maps, and AT&T and T-Mobile say they have good coverage. Even AT&T, if you look along the road, they break it down to stretches of the highway. You can see my house on there, and they say they've got 5G a lot for it. So the fact that other carriers are saying that they have coverage makes me think about that FCC ruling that we're all so scared about, that, oh my gosh, we can't do this. Does the FCC ruling say that every single carrier gets to have their desired level of coverage? And I guess it means if I want to start a cell tower company and I get licensed in Idaho, you then, since I have no coverage, would have to approve every single cell tower location that I decide to put up, because I'm a licensed company and I don't have any coverage. So let's not let the FCC's scare tactic crush us there when there's already multiple providers around. We just cannot let every single company get every single thing that they want. They also stated that, oh, there's 9 million people. It's the most dangerous stretch of highway. Oh no, the sky is falling. Well, I have something from the Idaho Department of Transportation right here. And this is for the mile stretch directly in front of the cell tower. In the last 15 years, there have been 18 accidents there. 1 a year. So that sounds horribly dangerous. Geez, I think Highway 95 is probably 1,000 times more dangerous than that. There was a whopping 2 crashes in 15 years that produced serious injury with 1 fatality. So there you go. That's supposedly the most dangerous stretch of I-90 in America. So just, you can add this to the record and add it later, but that's from the Idaho Department of Transportation. So he kind of brought it up. I was thinking a little bit, Dave Spiker's been my neighbor for a while, and so I'm not going to say anything, but I was thinking, why did he want a cell tower on his property? He has some real estate ties. He's got to know also that, that might lower the value of some of his splits. And he split it up into 4 20-acre parcels. That's much more valuable than 80 acres. And by the way, he has thought about moving there. He's not. So he's selling off. So he's not going to be a Wolf Lodge resident. And so I said, well, why would he want a cell tower on a property that he's getting ready to sell? It didn't make sense. I'm like, it's going to cost you some money, Dave. So then I said, let's see some of the pros and cons of cell towers. And there's a website called Steel in the Air. And their job is to help negotiate leases with cell tower companies for landowners. So I would argue they're probably pro cell tower. That's how they make their business. There's the number one reason to have a cell tower on your property: money. Over the course of 25 years, the average cell tower lease will generate a landowner $459,000. I like that last little part. This is just copied right off the website. It's probably better to be the landowner receiving revenue from it than being on a neighboring property and having to look at it while receiving nothing. And that's from the site that is promoting that landowners do this. And so I, of course, had to pull off some of the reasons not to have it. Aesthetics, they aren't attractive. They can have a negative impact. And some of the stuff's about tenants, but the bottom line is it proves that people don't want to be near cell towers. The potential to disturb neighbors. I guess I'm a NIMBY, not in my backyard. So bottom line is property owners, and this is from their website, don't like cell towers. So obviously the people of Wolf Lodge were not crazy. That there's a lot of people who are getting pretty fed up with all these cell towers that are getting put up. So, as you know, you voted once to deny the CUP. According to their lawyer, boy, you sure messed up because you didn't do anything right, is all I got from what she was saying. They submitted a scary rebuttal to you, lots of court, sightings and all kinds of things. So we're going to get into that because action number 4, that you asked them to provide evidence that it would mitigate those things. So what did they say? They basically said that none of the things we provided are applicable. That's where she kind of left off. Because we're talking about Georgia. Here's what I want you guys to think about. So bottom line is nothing that we did is applicable. The first survey says people, obviously, even though it's Georgia, people don't want to live near cell towers. They did not argue what the survey said. They just argued that, because it's not in North Idaho, it's not valid. Which means they agree in the city, cell towers, the closer you are to them, they hurt your property values. They didn't argue that. They just argued that, it's down in Georgia, that doesn't count. That shows also to me a big lack of understanding that living in the city, 10 feet from your neighbors is the norm. However, out here in the country, 50 feet, 100 feet to your neighbor would be on top of them. So they don't understand that people, when you move out to acreage, that you want to get away. And so if something is right on your border, that's like in your backyard. That's the truth about rural communities. So yes, a cell tower, even though it's 770 feet away, that could be the same as 10 feet in the city. The neighboring property is the same as the house next door. So that's the kind of mindset. They don't understand that. They probably don't understand rural living, but everybody here obviously does. And so they said what I said didn't matter because it was Georgia. I noticed all their court cases come from the woke liberal states of Washington, California, and New York. Throw Oregon in there and you just hit the 4 states you couldn't pay me to live in. My point is, what we do here, we don't need to worry what some California case went. They think completely different, and that's why everybody's leaving California, coming here. We don't want to deal with that junk. I think they're trying to trick you guys. They have stated multiple times, this cell tower is for the highway. We'll beam it down the highway so it doesn't go backwards. But yet, they try to throw out the fact that, people want cell coverage, so therefore we're actually helping your property values. They've stated, this is not for Wolf Lodge. And besides, I already have good cell coverage in Starlink Rocks. But if you don't believe me, this is, during the hearing examiner meeting, what the Verizon rep said. Volume, please. How do I pause it? Please don't count this against my time. The volume needs to work in this, please. Can you play it from your computer?
He's got it all the way up. There it is.
Put the mic next to it. Your mic.
Sorry, I was just going to say that the intent to target was not to think about the residences. Like, we know there's residences there, right? I can see it on an aerial map. But the objective is absolutely the highway. Okay, thank you. That was what I was going to...
their own words, this is for the highway, this is for the highway, this is for the highway. Yet they try to argue that they're bringing cell coverage to Wolf Lodge and it's gonna increase our, property values. They're trying to fool you. Don't fall for it. All right. Let's see if can we advance? Can you advance to the next slide, please? So far, those are the things that we talked about. I'm not covering what we did last time. I had local realtors tell you that cell towers decrease property values. I showed you the surveys that show you the closer you get to a cell tower. And we talked about how the less buyers there are, the tougher it is to sell a property. But let's hear from other people. Did you know Bonner County recently had a cell tower hearing? And there's a resident there who is worried about the cell tower, and their house is up for sale. Hit play, please. Or next one. Yeah, if you can put your phone up there again.
Our house, we were in talks with the realtor to sell our house. And then we get this notice in the mail that this is coming in.
The cell tower.
All of a sudden, that has to be disclosed in our sale, that there is this thing coming. And when they see, oh my gosh, what is this disclosure? They ask the realtor, this is what's happening. Our house is sitting on the market right now. We've already had to, we put it below market value because, one, there's a highway, there is a train, now there's going to be a cell phone tower. It's just like one thing after another. And
There you go. That's a homeowner who's having to deal with a cell tower come up, can't get their house sold. It's a lady, she's about starting to cry, and that's her testimony up in Bonner County. So you think I'm making this stuff up? I'm not. Next slide, please. I've got one more for you to hear, and these are from actual people moving here, buying acreage.
our house, we were in talks with the realtor to sell our house. And then
Hey, this is Mark Mathis. I'm with Rick. He has recently bought some vacant land, and I want to ask him a couple questions. So, Rick, you were looking at vacant land. I want to ask you a question. If directly on the border of the vacant land, and the vacant land already has great cell service, if there was a 200-foot cell tower directly on your border, would that make the land as attractive to you?
Be a no-go.
Okay, it'd be a no-go. So are you saying that if there was two identical pieces of land, that the one with the cell tower directly next to it would probably not be as attractive to a potential buyer?
Correct.
Do you think it would be, in order to get it sold for the homeowner that was right next to the cell tower, do you think they'd probably have to sell it for a less price to make it more attractive?
Absolutely.
Okay. And this is also a separate vacant land buyer. Justin, do you have anything to add? Do you agree, disagree with them?
100% agree with all the statements.
So you think a cell tower next to a acreage property that's 200 feet tall would probably decrease the property value?
It would decrease the property value.
Okay, and by some amount, okay. And I'm gonna show this in front of the county commissioners. Have I coached you in any way? Did I warn you at all on what to say? No. As a matter of fact, it was kind of weird that I brought my camera out and started filming you. Is that true?
That's right.
Okay, that's all I needed, guys. Thank you.
There you go. Two buyers moving here. I asked them about the cell tower coverage, didn't coach them. I'm a retired military officer, as you know, I don't lie. They told me I didn't coach them or anything, and they would not buy it. The wife of Rick said, I didn't know you were gonna do this and so I'm like, can I record you? She's like, no, I'm not ready. I didn't know you were gonna do this, and she didn't wanna be on camera. But she specifically said, we looked at a property in Plummer that we were all excited about. We got there, it was next to a cell tower, and so we turned around and left. So these are just two buyers, and they're not buying property because it's right next to cell towers. So this comes down, guys, to a bottom line is cell towers, the closer you are to a cell tower, be it in the city or in the country, your property values start to decrease. There is some truth to the applicants when they say places that have no coverage, if they get coverage, that can help that property. That is true. If you don't see the cell tower, but you turn on your phone and you have coverage, that does help. Well, that's the 15. I probably lost a minute with tech time. Remember, I already have cell coverage, and they have stated that this is not going to increase Wolf Lodge cell coverage. It's angled down the highway. And so bottom line is, it's just gonna hurt property values. And the only one to benefit from that in Wolf Lodge is the property owner, who's gonna get $459,000, and that's in a 25-year lease. This is a 45-year lease. Imagine that kind of money. Okay, thank you so much for my time. I very much appreciate it.
All right, Randy Neal opposed, wishes to speak?
Leslie, I'm going to read this into the
Oh,
record. Read into the record as B1, 2001. 2002.
all right. Hold on just a second, we'll get your timer up. Okay, go ahead.
Okay, so I have an article from Forbes Health up on my phone, and it's peer-reviewed, and there's citations I can provide if necessary. To date, more than 3,500 physicians across preventative and environmental medicine, toxicology, and other specialties have united against 5G, citing main associated risks with non-ionizing radiation according to peer-reviewed scientific literature, including cancer, cellular stress, genetic damage, reproductive changes and deficits, and neurological disorders. Sounds like something that the people of Wolf Lodge would just love to add to their life. One of the considerations is, I know that we cannot take the direct damage to the birds as a reason based on a law that's in effect right now. But one of the things that we can take into account is what's called ecotourism. One of the things that is unique about Kootenai County is we have this great, beautiful lake, and you can watch the eagles swoop down and catch fish, and that attracts tourists. The beauty of our county attracts people for camping, fishing, and other recreation activities. In fact, many of the restaurants in the city of Coeur d'Alene and throughout Kootenai County rely on tourism to produce money. So in a study by the Center for Environment and Vocational Studies of Kootenai University, researchers observed that after exposure to radiation from a cell tower for just 5 to 30 minutes, the eggs from sparrows were disfigured. The disfiguration of birds exposed to such a short amount of time to these frequencies is significant, considering that the new 5G network will have much higher density of these base stations, small cells throughout areas, including areas needing connection. The potential dangers of having so many small cells all over areas where birds live could cause whole populations of birds to have mutations and threaten their population survival. So all the eagles in that habitat right off the freeway would be at risk of extinction. As an American citizen and a patriot, I would like to speak against the installation of this tower for the good of our community, our tourism that we rely on, and thank you. Thank you for your time.
Randy. All right, Joe Whipple, opposed, wishes to speak.
Joe Whipple. I'm on Alder Creek Road, and my
glasses. These opinions are compiled from many people since last year and are offered with respect to all. From the CD Community Development Staff Report, quote, the proposed facility will be to fill the gap of communication along Interstate 90. Furthermore, due to the very small coverage gap, end quote there, we now know that essentially no one has come forward in public to complain of even a gap in service from either of these two carriers. We also know Verizon's response to CD staff request to provide supporting engineering data and generating RF maps was, quote, exact data about the sites is proprietary and cannot be disclosed due to competitive reasons, end quote. We concur with Commissioner Matari in his pre-decision statement on January 11th. We also concur with Commissioner Duncan in her opinion. She took into account the fire hazards and other issues considered important to her constituents. We all question the current federal RF health data as it minimizes risks, is outdated, and is highly suspect. While we respect Commissioner Brooks, in our view, the applicants are the ones who provided anecdotal-like evidence, specifically the assertion from their request for reconsideration, or RFR, quote, HE 2002 sufficiently evidences the significant gap in coverage with real-time data. Verizon's drive test data in real-time drive data created by Verizon employees. The implication here is that their secret in-house testing data somehow qualifies as scientific investigation and thus, quote, substantial evidence, end quote. Sadly, there's a huge monetary component clouding the applicant's intent to rely on their own data. Therefore, it is in best in-house statistical evidence closer to anecdotal and questionable. The assertion that there is a significant gap in coverage had already been settled last fall. Again, it is only a very small coverage gap in the staff report. From an out-of-state petitioner, the RFR is rather insulting. In it, the applicants fail to consider that the BOCC respectfully represents nearly 200,000 citizens. To the BOCC, such statements such as the board failed and the board ignored are plentiful. The citizens' concerns are disparaged as the board relied on, quote, public hearsay and speculation, end quote. The RFR reads as a complaint to the court warning the BOCC to capitulate or off to the Frequency Allocation Agency, aka the FCC, they'll go seeking to force compliance. From the beginning, the entire CUP petition failed to prove both the least intrusive means in mitigating the gap in coverage and providing substantial evidence of the existence of a significant gap in coverage. Therefore, this time the BOCC should unanimously deny their CUP application request. Thank you.
Thank you. Eugene Kalinowski? Sorry. Go ahead. Opposed wishes to speak.
Yeah, I was speaking last time.
Hang on one second.
Read into the record as B 2003.
Go ahead.
My name is Eugene Kalinowski. I live in North Idaho. I came from New York 3 years ago for the reason of my office, like everybody comes here. I didn't agree what's happening in New York, so I came here.
Please speak up.
All right. So I want to add a few things that nobody talks about here. I overheard that there is a law that we cannot speak about the health impact from those towers because it's a federal law. It's unconstitutional. I just want to point it out. How we cannot speak with the First Amendment rights.
You may speak to that. We cannot use that as consideration for our decision.
It's the same. It's your rights to decide. It's a deviation of your way of thinking, impacting your way of thinking. It's a law made up for the reason, because this is the main thing that now, how can you justify health impact? How do you regain the healthy? The people are coming to, they cannot come to the church because they are affected by the cell phones in the church that accumulated, and they get sick for days. So they refuse to come to the church. There's no doubt that the towers are impacting negatively the health issues. The other thing I want to point out, it takes only a few words to say the truth. Over here, I hear So many education people speaking about science, proof, the logistics, the construction things and the study and so forth. This is just, in my opinion, to make people tired and they just want to give up and they may feel intimidated that they know nothing, the scientists know everything. But in the reality is why we saw the people want to buy the property. If there is a tower, they quit. They turn around and go away. I did the same thing. I look at the properties, and when I see a tower, I just turn around and go away. For that particular reason. So they talk about the economic impact, they talk about the social impact, but they don't talk about the health impact. Why? Why such a denial? Why everybody afraid of speaking what the really truth is? And I like the gentleman was talking about the nature. I'm also for nature, and I think it's very, we have a chance to preserve what it is now. If we allow this tower to be built up, we kind of allowing to slide down, and the whole environment that we have now will go away, and it will change in 10, 15 years probably, and very fast, as we see. And those 5G towers or whatever, 4G even, they're not really for health. They create for profit for those companies. Those people don't live here.
Okay.
They're just making money here.
Thank you.
Thank you.
Okay. Is it Ratrina or Katrina? Motola? Katrina? Wishes, opposed, may wish to speak? No? Okay. All right. Annie Wilder, opposed, may wish to speak.
I would just agree with.
Ma'am, if you're going to speak, you have to come to the microphone. I'm sorry.
Raise our hand if you wanted to agree with someone.
Yeah, you can just, if you're going to speak, you need to come to the microphone.
My name's Ann Wilder. I live in Priest River. I don't want a cell tower by my house, and I agree with what Joe Whipple said. Thank you.
Thank you. Roger Dunham, opposed, may wish to speak. Okay.
Roger Dunham, I live in Athol. I think the board was right to deny the first application. I don't see that anything's really changed. They've just resubmitted. As far as I'm concerned, I think that the health issues need to be addressed, especially with 5G. I think aesthetics, it's hard to argue that a cell tower is aesthetically pleasing. I think in terms of fire damage, I think it could very well initiate that as an antenna just coming up out of the ground for 150 feet. It seems to me that property values would definitely decrease, and I think the real estate people have mentioned that, and other people have said the same thing. I certainly would, if I was selling a piece of property and a cell tower came in nearby, I would expect my value to drop. And I think our investment here is in real estate, and I think that the board was right to deny it, and I think it should be denied again. Thanks.
Thank you. Brent Regan, opposed, may wish to speak.
Brent Regan up in Morley Road, Madam Chairman, Commissioner Matari, thank you for giving me this opportunity. I have lived here long enough, almost 30 years, to have gone through a bunch of different systems for getting broadband, Wi-Fi, internet service, and that's what cell phones are. It's just a data system. Started off with geosynchronous satellites, and then various radio modems to various places, and now I have Starlink. And, you know, we've had various systems of cell phones. We've had 3Gs, which is now obsolete, 4G, which is now obsolete, 5G, which will be obsolete soon and probably replaced by direct satellite phones with low asynchronous orbiting satellites. The problem is that electromagnetic radiation comes in a variety of frequencies from DC to daylight, and your eyes happen to be sensitive to one of the higher frequencies, which we call visible light. Higher frequencies like 5G act more like light. Low frequencies act like sound. The sound goes around corners and gets into valleys and crevices where high frequency doesn't. So in a hilly environment, 5G really doesn't work because it doesn't get down into the valleys where the houses are and the roads are and so forth. What it does, though, is it adds to the electromagnetic radiation pollution in the area. You know, if you go to a city and there's a lot of light pollution, you look up up in the sky, you can't see the stars, okay, because of that pollution. Well, if you live out in the country, you can see the stars, and if you need a satellite reception for very low power satellites like they're going to have on phones, you can see the satellites. Your phone can see the satellites because there's not a lot of noise around. We put 5G towers everywhere, and all of a sudden the ambient noise, the electromagnetic noise goes way up, and it's much more difficult to see those little tiny dots of satellites that are zipping by in low Earth orbit. So the neighbors don't want this. 5G is going to be obsolete soon. We know that because every technology that we've had has become obsolete soon. And the next technology that we're going to have is probably going to have a conflict with the existing 5G technology. The proper role of government is to protect the rights of the citizen. The citizens, the residents of the area, don't want this. Protect their rights. Thank you.
Thank you. Hands up, please. Thank you. Thanks. All right, Michael Burns, opposed, does not wish to speak, and if you change your mind, please let me know. Mark Eberlein, opposed, does not wish to speak. And Mary, is it Marin? Opposed, does not wish to speak. And Jen Noel, opposed, does not wish to speak. All right, anybody on Zoom?
Everyone that's on Zoom has already spoken.
Okay. Then I think we are to our 15-minute rebuttal.
I did want to add, Madam Clerk, if you wouldn't mind adding an exhibit number to the email that I received that I will be forwarding to make it a part of the record.
That'll be read into the record as B 2004.
All right. Ms. Watanabe, are you leading the rebuttal?
Sure, I would take the time and then reserve some for Mr. Weiss if he so chooses.
Okay.
Can you hear me okay?
Yes.
Okay, I'll go ahead and start. Thank you very much. I respect the comments from the public. I would like to make a request that the comments about 5G and health effects get totally stricken from the record. And with all due respect to the one gentleman, the reason why it's not discussed is because it's not within the legal jurisdiction of county, and the county's legal counsel knows that, and the commissioners know that. So I'm just going to ask that be stricken from the record, and obviously I'm assuming it's not going to be part of your further decision on the reconsideration. I would like to lead you on the continuation of the property values. Please take a look at footnotes 14, 15, and 16 and my reconsideration, where I do provide evidence about how property values are not adversely affected and how broadband does bring a benefit. And I appreciate I think it was Mr. Mathis acquiescing to that and acknowledging to that. Let me just quickly say, for a business plan and profits and money making on a project, that is not something that comes into the decision making, so that cannot be part of it in terms of an applicant's profits. That's not an issue up for discussion and deciding. And, proximity to neighbors, I live in a rural area, you're making assumptions about where I live, and it's all about perspective of what someone thinks is close or not close. So that's just a matter of perspective. In terms of benefit for the highway and not benefiting the Wolf Lodge people, I would suggest that benefiting the public health and safety and welfare is definitely a worthy goal for the commissioner. There's not just 10 people living in the county, there are many, many. And in terms of ecotourism, there are many, many, many people who come through those corridors who would like to have the safety knowing that they can get out and reach emergency services should they need them in the more beautiful remote areas Idaho. And in terms of, talking about this, people who there's only 2 people that AFIS showed who are not potential, don't want to sell tower. I had made prior testimony that the applicant has sold way more than 2 properties to people who bought a piece of property with the tower on or immediately adjacent to them, and they did not mind. So again, that's a matter of perspective, and the hearings examiner got it right when he did not lay claim to having a basis to make a decision based on property values, and he made the right call. So in terms of like a cell tower, it's like a utility. It's a utility. There's power lines everywhere. I just kind of want to bring that up because the cell tower is a utility. Again, gap in coverage, it's a legitimate gap in I-90 service. That's a legitimate reason, and the gap in service that we established. And I want to make a quick flip over to the discussion about least intrusive means. And I didn't lift it out earlier, but I'm going to now, and that's going to be in footnote 3 of the reconsideration in its case law. And that basically says that a provider has made a showing that a proposed facility is the quote-unquote least intrusive means of filling a purported gap in coverage where it submits evidence that it considered alternatives and provides adequate explanations as to why they are not feasible alternatives to meet the provider's coverage. And I would suggest to you that Verizon and Inland have provided that evidence into the record to establish the least intrusive means. And in terms of ecotourism, again, we did supply a full NEPA as a federal document of environmental issues, and there were no issues with birds. So I would just like to reiterate that again. That's also in the record. And I just want to just kind of wrap up where I was, and that is really to suggest that the evidence in the record, with all due respect, submitted by the public, is not dispositive, and it's misplaced and misguided as to the specific facts and conditions of the tower that's proposed before you. So I would suggest and respectfully request that you reverse your denial and approve this, suggesting that your denial, which was, in our view, not based on substantial evidence in the record, and will have prohibits or has the effect of prohibiting Inland Cellular and Verizon from providing personal wireless services in the service gaps that have been identified with each carrier. And so with that and the other reasons in the reconsideration, we respectfully ask that you reverse and approve the CUP. So I want to thank you all for your time, and I'm going to leave any remaining time to Mr. Weiss if he chooses, or questions if there are any. Thank you.
Mr. Weiss has declined any further comments, so are there any questions?
I just have a couple. I'm going through your letter, and towards the end it says that people want cellular and broadband service. Are the two interchangeable, or are they separate?
If you don't mind, I would like to have Mr. Weiss answer that question because it's more technical, and he will be able to explain that better in terms of the services we provide with the tech.
Well, I'm just referring to what was in your letter. It's on page 8, the last paragraph.
Well, cellular is mobile, and broadband is kind of faster, higher speed. Nathan can correct me, but in my mind, cellular is mobile, wireless, and broadband does provide higher speed data.
Okay, so then on page 9, on the top paragraph, you say having access to broadband makes a community livable and desirable and increases property value. Are you referring to cellular or broadband as you just described it?
I would think that that particular study was really discussing about broadband, and that would be in the footnote 13.
Okay. And what about this next paragraph? It says broadband access can increase property values by at least 3% according to a 2019 study. Is that referring to broadband in a general sense, or is that referring to broadband through cellular?
I would say it's broadband access in general in terms of data and fiber.
Okay, so it isn't necessarily specific to cellular broadband. And then on the going back to page 8, the third paragraph from the top, there's a comment that's in here. It says the temporal effects of cell towers were also examined, and it was found, excuse me, it was found that the discount associated with proximity to a tower is smaller during times of upward trend home prices versus times when home prices are falling. But it says that there's a discount associated whether prices are going up or going down. So does that not mean that there is a discount with real estate compared to the proximity to the cell towers? Isn't that what that is saying?
I would say you could read it that way. But again, I would clarify that property values in Idaho, like I mentioned, are trending up. And I would also suggest that the variables are just too many to really state whether or not there's going to be a negative or positive effect. And I agree with the hearing examiner's analysis that he reached the right conclusion.
Yeah.
And you can go back and forth, and you could have people stand up. I could get 5 people to stand up and say, I'm happy to live by a cell tower, because it's just not dispositive in terms of making a conclusive decision to deny or approve. So I believe the hearings examiner did a proper analysis of.
Yeah, okay. All right, well, those were my questions. Thank you.
Thank you.
I do not have any further questions as well, so I guess I would entertain a motion to continue deliberations to June 13th for the reconsideration. But first, I'd like to ask Pat a question. When our options for the reconsideration are to find in favor of the appellant, which then reverses our original decision, or find against the appellant, which upholds our original decision. Is that correct?
You can affirm your prior decision, reverse it, or modify it, or you could remand it to the hearing examiner or to community development staff. Those are your complete list of options.
Okay. Any thoughts or questions? You just want to end public testimony and deliberate on June? In June.
June 13. Yeah. I do have a question about this letter that was signed by Ryan Novak, a president of Novak Insurance. I don't know who would be the appropriate person at the appellate side to answer that. But one of the things that I'm just curious about is, has this person underwritten insurance in the inland Northwest, in rural areas where the forest is dry and typically a little more dense than Ohio?
Yes, this is Ann, and Novak is a national carrier, and Towerco is a national cell tower company. They own, manage, and operate cell towers nationwide. We have partnered with them on rural sites, so I can tell you that, yes, their insurance company is providing coverage for rural towers, but we used to own that acquired from us in rural areas in Idaho.
Okay. But do they do homeowners insurance?
Yes, they do.
I'm sorry, you broke up.
Yes, they do.
Is that a yes?
Yes.
Okay. Thank you.
All right.
That's it. I'm fine with moving the deliberations to June 13.
Are you ready to deliberate now?
No, I'd like to think this through a little more and articulate my thoughts in something that can be put into the record.
Okay. All right, motion.
I move that we continue deliberations to June 13th, 2024 for CUP 23-0003.
While ending public testimony.
While ending public testimony.
Second.
Commissioner Matari?
Aye.
Chair Duncan?
Aye. Thank you, folks. 8:25, meeting adjourned.